Morning. Call to order the eighth meeting of the Rhode Island Ethics Commission, eighth meeting for 2025. Record reflect that we have quorum, you full house. And I want to announce before we start that I have to leave at 10:30. If we have not completed the agenda by 10:30, 10:25, we'll take a 5-minute break. I'll leave, vice chair will take over. I want to emphasize that despite my need to leave, I don't want anybody to feel rushed today. Take whatever time you all feel is needed for the discussion. That said, first item on the agenda is the motion to approve the minutes of the open session held on April 29, 2025. Fair motion, so moved. Motion by Commissioner Callahan. Is there a second? Second by Commissioner Browner. Roll call vote. Commissioner Susie.
Aye.
Commissioner Strauss.
Aye.
Commissioner Browner.
Aye.
Commissioner Centerini.
Aye.
Commissioner Callahan. Aye. Commissioner Peterson.
Abstain.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
Chair votes aye. I am going to also now take out of order item number 4, discussion and vote to initiate formal rulemaking. Amending the Code of Ethics gift rule at 520-RICR-00-00-1.4.2 to expressly include registered lobbyists within the definition of interested person, and to raise the maximum allowable gift values to be more consistent with the changes to the Consumer Price Index since 2005. I want to indicate before we begin that we should not be looking at this necessarily as a single agenda item, but as 2 agenda items. There are 2 proposals before us. And so I want to make sure we're aware that we could vote one way on one and one way on the other if you so choose. Perhaps the easiest way to start this would be to see if there's a motion anybody would like to make.
Mr. Chairman, is it possible that we have individual votes on the various items that are included here, each section?
I think we should vote on each proposal, but not internal to each proposal. We have 2 proposed rule changes. Our decision today is, for lack of a better word, merely to determine whether we're going to go forward and engage in formal rulemaking. If we're going to engage in formal rulemaking, then I would think if you're concerned about individual matters within a proposed rule, that would be the time to discuss that. We do not have any obligation, if we choose to engage in rulemaking, we do not have any obligation to accept what has been proposed to us. We have the authority to modify it, to adjust it, to do what we think it should do. So my view is that today what we have before us really is the question, are we going to engage in rulemaking on the gift rule? Are we going to engage in rulemaking on interested parties?
Could I ask a clarification? Where the pages that require publication, does that require publication of the specific rules that we're considering, or just the subject matters?
I believe it requires publication. The rules we're considering, but executive director clarified.
And assuming that we enter the rulemaking process, and based upon either public comment, written comment, we adopt or we move towards something different than the proposed rule, do we have to start again? That's why I'm interested in separate consideration.
The answer clearly to that is no. It's a process that begins with document A. It's kind of like legislation. We could end up with sub B, sub C. They would be called that as we go through the process. Once it's initiated based on a proposed rule, it proceeds not based on that rule, but into the process. And now we are open, as I said before, to modify what's been proposed. We don't have to give additional notice of the changes to the rule, if we have additional hearings, of course, those will require public notice, but the actual process, we are not bound by what is before us.
Okay, thank you.
So let me ask this way.
Oh, Mr. Chairman, I'll make a
Yes.
motion that we move forward with rulemaking for the interested persons.
Is there a second?
I'll second.
Motion by Commissioner Rabideau, seconded by Commissioner Peterson. Any discussion? Hearing none. Roll call vote, Commissioner Susie,
Aye.
Commissioner Strauss. Aye. Commissioner Browner. Aye. Commissioner Centerini,
Aye.
Commissioner Callahan. Aye. Commissioner Peterson,
Aye.
Commissioner Rabideau,
Aye.
Commissioner Ritchie.
Aye.
The chair votes aye. Is there a motion with respect to the proposed rulemaking on gift limits?
So move.
Motion by Commissioner Centerini,
I'll second it.
seconded by Commissioner Rabideau. Roll call vote, Commissioner Susie,
Aye.
Commissioner Strauss. Aye. Commissioner Browner.
Aye.
Commissioner Centerini,
Aye.
Commissioner Callahan. Aye. Commissioner Peterson,
Aye.
Commissioner Rabideau,
Aye.
Commissioner Ritchie,
Aye.
and the chair votes aye. That was easy. I would note for the record that we had a quick discussion today. We've been discussing this for at least the 3 past meetings. So I think the way things have gone, maybe, Jason, let's do the executive director's report this time. Great.
Morning. Yeah. So just to note a few things. First, I'll note for anyone in the audience or anyone who's watching the live stream that all of the meeting materials, including copies of the proposed regulations at this point, are available on the commission's website for viewing and downloading. Copies of the draft advisory opinions are also on the website currently. So just going through briefly on complaints and investigations. We currently have 4 complaints that are pending for now. We just had a new one filed, and that would be initially determined today during executive session. The other 3, there's not a whole lot to report on. Of course, some complaints, still discovery ongoing in that particular case. As far as I know, the depositions have not been scheduled yet. So moving on to a Weston Rogers complaint, as you know, that's post probable cause. And at this point, respective counsel are in the process of discussing whether or not this is going to go to an adjudication or whether there's any possibility of an informal resolution settlement. And if not, then coming up with an adjudication date. So if that goes to adjudication, I would expect that we would hold it probably sometime this summer. July, August. Estimation. The Charlie complaint is under investigation, not yet to probable cause. Probably look for a probable cause hearing on that again. So, and then we'll see what happens with the initial determination today. That's complaints and investigations. Moving on to advisory opinions. We have 8 advisory opinions pending right now. 5 of them are on today's agenda. So as you can see, we finally got through that strange kind of rush of advisory opinions that we've had this entire spring. Thanks, credit really there goes to our 2 staff attorneys, both of our advisory opinions, Radishis and Gabriel Papa. APRA requests, we had 11 since the last meeting. We completed all of them within 1 business day rather than waiting for 10 days that we could. And they kind of ran the gamut. 1 related to just meeting materials, 6 related to advisory opinions, 3 related to recusal statements, and 1 asked for a copy of our fine schedule that we adopted last year. We provided that. Just briefly then on financial disclosure, just to give you an update as to where we are with the filing season, the 2024 filing season. As of this morning, we are up to 95%. So we've really had a lot come in. That puts us 3% higher today than we were last year. So last year, on this date, we were at 92%. Today, we're at 95%. And just to give you a breakdown with what that is, so that's about 200 non-filers. And of them, 60% of them are municipal officials. That's usually our largest. Most of our filers are municipal. 20% of the non-filers are charter schools. Always difficult to track down the charter school board of directors. Because they're a mix of parents of students and people who aren't necessarily really government. Then 15% are state boards and commissions, and 5% are what we call regional, mostly fire districts. What's going on is that our investigators are reaching out to these people individually, and that's why we're getting so we're individually emailing and calling people. That's how granular we get in reach out. I would expect that we'll be close to 100% by start of August, and then those last few people will be filing complaints against once we get down to those numbers. That is about it. Let's see, the next meeting is June 10th.
Office administration.
And there's not general office administration, there's not too much that really needs to be talked about here. We're about to get an intern, as we get every year, which is nice. So I think our intern's going to help us with some of the rulemaking, especially if there's any additional research. He's a political science student at the University of Rhode Island. Been working with them for the last 4 years, getting us some research associated. Legislative update, I have nothing to report. The 2 bills that we had been tracking, there's just no further action on as far as I can know. No additional legislation has been introduced.
I would like to just ask. I want to be careful because they're not present, but does it make sense to bring the parties in on horse? Get a direct report from the parties. Been quite a while. When you tell us the depositions haven't been taken, that concerns me. So I don't know what the rest of the commission would feel, but.
Actually, to find out why they haven't.
Correct, no merits, we stay on the merits, but I guess I'm gonna lean toward you to find out whether from your perspective, and I want to be careful, from your perspective, there's a reason to have a meeting.
So I think a status type conference is always valuable in any kind of litigation or case, and we certainly could ask the attorneys to come in for a status conference about where are we with discovery, where are we with this case. I could also reach out and which I will. Either way, I'll reach out to counsel. But certainly, if you wanted to request a status conference for the next meeting, we could arrange to have that. Ask counsel to come in.
Just to refresh my recollection, when had we approved the discovery?
Jason could tell us better than I, but.
I actually made a note, and I didn't bring that.
Months, probably more than a couple of months. I mean, they had to get to Pennsylvania and get the
Right,
authority there.
right, Rhode Island.
They had to do all that foreign deposition stuff, and there was difficulty apparently serving them. But it's kind of reached that point where, in my mind at least, I like to hear from the parties, get a status.
We could, again. Lawyers are the state. And you legally bind. Why it's, and then pay that back to us, and then at that point, we have
I'm not asking on state council to come. Remember that they're in state council. They simply have out-of-state counsel for the purpose of taking the deposition. So I would not be
I
asking
understand.
or suggest that out-of-state counsel be brought in.
Nonetheless, in light of the, with the issue, I think perhaps, I think we've already, why stated so if that's necessary, so I think that.
Here's the problem. The director is the prosecutor.
Well, then the chair.
I don't think that's proper role for the chair. That's why I'm suggesting we bring them in. I shouldn't be getting information that isn't coming to all of you.
Sure.
So I believe the proper approach here would be to ask them to come for a status conference. Just as you would if you were, lawsuit and had parties that you felt weren't, I don't want to say that because I don't feel that way, but you felt weren't moving something along.
We are judges here. Well, so in that sense, we just on our own get it right. So that's the chair. I can do that.
My preference would be to have the executive director coordinate. I think a status conference would be appropriate. And for a couple of months, you stop to say, okay, what's happening? I think that's what we should do, and I would make a motion that through the executive director, status conference be established.
There's a second.
Second.
Motion by Commissioner Santorini, second by Commissioner Susie. Roll call vote, Commissioner Susie.
Aye.
Commissioner Strauss.
Aye.
Commissioner Browner.
Aye.
Commissioner Santorini.
Aye.
Commissioner Callahan.
Abstain.
Fair enough. Commissioner Peterson.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
Chair votes aye. So we'll ask you to arrange for them to be here, and if there's a conflict or whatever, let us know. Schedule it if need be, but I just don't want to see this go much further down the pike without some sense of schedule.
As a point of order, Chair, it was on the agenda on September 20th.
The
So it's
last,
been quite a bit of time.
Yeah,
that's when we approved it.
That's when the discussion was. I can't recall if we approved it that meeting or the next meeting, but it's been more than 6 months. I think it's time to touch base.
Agreed. Is there a sign up sheet? First matter on the calendar, sign up sheet. It's Brian Solomon, PE, an alternate member of the Smithfield Zoning Board of Review. Morning, Mr. Bowman.
Good morning.
good morning, commissioners. This draft is on the top in the binders. Mr. Thalman is a first alternate member of the Smithfield Zoning Board of Review. He, as such, he attends the meetings and he participates in the discussions of the matters. However, he only participates in the vote of the zoning board when an alternate is required in order to achieve a quorum. In his private capacity, he is a professional engineer. He seeks guidance regarding whether he is prohibited by the Code of Ethics from participating in zoning board discussions and decision-making relative to an application for a dimensional variance, allowing the applicant to construct a detached garage on his property that is part of a subdivision. Mr. Thalman was the engineer for that subdivision. The petitioner represents that the subdivision comprises of approximately 32 to 33 single-family homes. He states that he was hired by the developer to design the subdivision. He completed that work in or about 2008, and he was compensated for his services, and there are no outstanding balances remaining. He does not have any current business relationship with the developer, and he doesn't have any current or former business relationship with the applicant homeowner. The petitioner further states that no information that has been provided by the homeowner as part of the application package contains any plans that he had previously prepared for the developer. And his work is not currently under review by the zoning board. Now, under the code of ethics, a public official may not participate in any matter that will directly financially impact him or his business associate. And among others, provisions of the code, he's required to recuse from any matter if his business associate appears before him in his public capacity. Here, the petitioner represents that the applicant is not his current or former business associate. The petitioner states that none of his plans are under review or challenged. Therefore, the provisions of the code of ethics do not apply here. And it's accordingly it is the opinion of the staff that Mr. Talman may participate in the zoning board's discussions and decision making around to that application. I don't know any questions you may have on this. Thank you.
Good morning, Mr.
Good morning, Mr. Chair.
Do you have any comments or questions?
I did this out of an abundance of caution. I know that municipal boards are under a great deal of scrutiny, and I just felt it was in everybody's best interest to request this opinion, just to make sure that I was on par with what is allowed.
We like abundance of caution. Any commissioners have questions for Mr. Dahlman or Ms. Papa? Is there a motion to approve and issue the advisory opinion as presented by the staff?
So moved.
Motion by Commissioner Callahan. Is there a second? Commissioner Browner? Roll call vote. Commissioner Susie?
Aye.
Commissioner Strauss?
Aye.
Commissioner Browner?
Aye.
Commissioner Samarini?
Aye.
Commissioner Callahan?
Aye.
Commissioner Peterson?
Aye.
Commissioner Rabideau?
Aye.
Commissioner Ritchie?
Aye.
And the chair votes aye. Thank you, Mr. Tallman.
Thank you very much.
The next person on the sign-up sheet is Jason Broder. Morning.
Morning, everyone. The tab for, the draft for this petitioner is at tab B in your binders. Welcome, Sergeant Broder. Petitioner is a sergeant with the Warwick Police Department. He joined the department in 2011 as an officer and was promoted to the rank of sergeant in 2020. In 2023, he was assigned to the Administrative Services Division, the ASD, where he is now one of 2 sergeants. Both sergeants report directly to the ASD officer in charge, who is either captain or lieutenant, depending on the schedule's rotation. An administrative major oversees the entire ASD. Both sergeants oversee the ASD Communications Center, which is staffed by 16 civilian full-time dispatchers who are tasked with answering non-emergency and emergency calls for service, and then dispatching officers to respond to those calls. The Communications Center is a 24/7 operation, and there must be at least 2 dispatchers on duty at all times. There are 3 shifts. The first shift is 7 a.m. to 3 p.m. The second shift is 3 p.m. to 11 p.m. And the third shift is 11 p.m. to 7 a.m. The petitioner and the other sergeant, whose duties are identical, work the first shift together, Monday through Friday. When the petitioner and other first shift sergeant are off duty, supervision of the ASD dispatchers falls to the captain or lieutenant in charge of patrol, which may or may not be the captain or lieutenant assigned to the ASD. The petitioner's nephew recently ranked first among the applicants for an open civilian dispatcher position following the completion of a written test, a typing test, and an interview. The petitioner was not involved in the selection process. That his nephew had applied for the dispatcher position came to the petitioner's attention when the petitioner arrived to greet the applicants as a group to explain the demands of the position, such as the requirement that dispatchers work at night or on weekends, holidays, third shift to start, just in case anyone wanted to at that time change their mind and withdraw their application rather than continue. The petitioner saw his nephew in the group of candidates. He immediately notified the ASD lieutenant of his conflict of interest and removed himself from any involvement in the selection process for the new dispatcher. He adds that the ASD lieutenant, the other ASD sergeant, and someone from the city's personnel division interviewed the final candidates. If the petitioner's nephew is offered and accepts the dispatcher position, he will serve a 6-month period of probation, during which his employment could be terminated without recourse under the just cause provisions of the collective bargaining agreement between the city and the union to which the dispatchers belong. The new dispatcher would start out on the first or second shift and be trained by the more experienced dispatchers, as is custom, who would then provide feedback to the sergeants and lieutenant regarding the progress of the new hire. Ordinarily, both the petitioner and the other ASD sergeant would participate in the training of the new dispatchers and provide input on a new employee's probationary period performance. Neither sergeant exercises any discretion with regard to dispatcher overtime, the process for which is described on pages 2 and 3 of the draft. Routine matters of discipline, such as counseling and/or verbal or written warnings, can be dispensed by the ASD sergeants. Matters of performance and discipline move up the chain of command to the ASD officer in charge, and serious matters that could result in suspension or termination are brought to the major or deputy chief, who will then work with personnel to determine an outcome. Clearly, there are conflicts of interest that would result because of the petitioner's role as a sergeant in the division by which his nephew is expected to become employed as a civilian dispatcher. But the Ethics Commission has addressed similar circumstances in a number of advisory opinions issued to municipal public safety personnel whose family members were employed by the same agency. 3 such advisory opinions spanning from 2005 to 2018 are cited on page 4 of the draft. A proposed and reasonable alternate chain of command is necessary under the circumstances, and the petitioner offers the following for the commission's consideration. Any matters concerning his nephew's training, supervision, evaluation, discipline, and/or decisions regarding his nephew's work hours or requests for furlough, which carry with them any amount of discretion on the part of the petitioner, will instead be performed by either the other ASD sergeant or the captain or lieutenant serving as the ASD officer in charge, or in the absence of the officer in charge, by whoever is covering for that person. The petitioner represents that the other ASD sergeant and their superiors within the ASD agree with the proposed alternate chain of command. Keeping prior advisory opinions issued under similar circumstances in mind, it is the opinion of staff that the proposed alternate chain of command in this instance is reasonable and sufficient to insulate the petitioner from apparent conflicts of interest. As has been noted in prior advisory opinions, during discrete emergency situations where incident-specific supervision of his nephew may be unavoidable, no nepotism violation of the Code of Ethics will exist for the petitioner. Petitioner is encouraged, however, to remain vigilant about identifying and avoiding any conflicts of interest that might arise given his nephew's position that are not addressed in the draft, and is encouraged to seek additional guidance from the Ethics Commission as needed. I'm happy to answer your questions or to defer to Sergeant Broder as appropriate.
Morning, Sergeant Broder. Do you have any questions, concerns, comments regarding the proposed advisory?
No.
Can you understand the last paragraph on the import of the last paragraph that in an emergency situation, you have to do what you have to do?
Yes.
Do what has to be done. You understand that?
Yes.
That's an important piece of this. Members of the commission have questions? Issues for either Sergeant Broder or issues? Hearing none. Is there a motion to approve and issue the advisory opinion that's presented by the staff? Todd. I'll give the tie to Commissioner Rabideau today. Second,
He's good at that.
is there a second?
Second.
Second by Commissioner Brown. Roll call vote, Commissioner Susie.
Aye.
Mr. Strauss. Aye. Mr. Browner.
Aye.
Commissioner Centerine.
Aye.
Mr. Callahan. Aye. Mr. Peterson.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie. And the chair votes aye. Thank you, Sergeant.
Next week.
I might say before you leave that, it was wise of you to recuse at the moment you recused.
Very, very aware.
Commissioners, that was the last of our petitioners who are present today. I don't know whether you'd like to pick up with tab A.
I'm gonna pick up with tab A. And go through the rest in order. The next tab is the Honorable Frank H. Cohen or Ciccone. Anybody know the correct pronunciation?
Both ways, Ciccone is the, more
Do you know how,
national way, Ciccone is more
do
American.
you know how he pronounces it?
Ciccone.
Ciccone? Okay. The Honorable Frank A. Ciccone III, a legislator serving as a member of the Rhode Island Senate.
Yes, Senator Chacon could not be here this morning. He had to be in Westerly for 9:15. The petitioner is a legislator serving as a member of the Rhode Island Senate. He represents District 7, which encompasses Providence and Johnston. Originally elected in 2002, he has served continuously since. He was recently elected to the position of Senate Majority Leader. There is legislation currently pending in the Senate for which the petitioner is not a sponsor, which, if passed, would establish the Rhode Island Assault Weapons Ban Act of 2025. The act would define various assault weapons and restrict the manufacture, sale, purchase, and possession of those assault weapons. The act would afford the owner of an assault weapon 5 options. The draft describes them in more detail on pages 1 and 2, but basically, an owner can 1, register the weapon with the local police department, 2, render the weapon permanently inoperable, 3, surrender the weapon to the local police department, 4, surrender the weapon to a gun buyback program, or 5, transfer or sell the weapon to a federally licensed firearm dealer or to a person or firm lawfully entitled to own or possess it. The petitioner holds a federal firearms license, an FFL, to deal firearms other than destructive devices. There are 99 FFL holders in Rhode Island, all of whom would be subject to the legislation, which constitutes the entire industry in this state. Of those 99 FFL holders, the petitioner is one of 80 who deal firearms other than destructive devices. The remaining 19 FFL holders are manufacturers of ammunition and firearms. The petitioner states that he derives little, if any, income from firearm sales and that it has never been his primary source of income. He clarifies that he mainly uses his license to complete a few transactions each year for friends and family. The petitioner has asked for an advisory opinion regarding whether he is prohibited by the Code of Ethics from participating in Senate discussions and voting on the Assault Weapons Ban Act, given that he holds a license to deal firearms and would be subject to the legislation if it passes. Under the Code of Ethics, an elected official may not participate in any manner if he has a substantial conflict of interest. That is reason to believe or expect that in this case, he will be directly financially impacted by his official activity. This comes from section 3614(5)(a), as further defined by section 3614(7)(a). Section 7B of the code, often referred to as the class exception, states that a public official will not have a substantial conflict of interest if any benefit or detriment accrues to him, quote, as a member of a business, profession, occupation, or group, or of any significant and definable class of persons within the business, profession, occupation, or group, to no greater extent than any other similarly situated member of the business, profession, occupation, or group, or of the significant and definable class of persons within the business, profession, occupation, or group. When determining whether particular circumstances justify the application of the class exception, the Ethics Commission considers the totality of the circumstances. Among the important factors to be considered are a description of the class, the size of the class, the function or official action being contemplated by the public official, and the nature and degree of foreseeable impact upon the class and its individual members as a result of the official action. The Ethics Commission has previously concluded that application of the class exception was justified in a number of matters involving proposed legislation. 4 such advisory opinions appear on page 3 of the draft. Here, the petitioner is one of 99 members of the class of FFL holders who would be impacted by the passage of the act. He would be impacted by the legislation to no greater extent than any other individual member of the class of 99 FFL holders or the subclass of 80 FFL holders who deal firearms other than destructive devices to which he belongs. It is therefore the opinion of staff that the specific facts of this case justify the application of the class exception as set forth in section 36-14-7B, and that the petitioner is not prohibited by the Code of Ethics from participating in Senate discussions and voting on the proposed legislation. However, in the event that his participation at any point veers into revising the proposed legislation in such a way that it would impact a smaller class or subclass of FFL holders, or impacts the petitioner individually or differently than the other FFL holders to which the legislation would apply, he should either recuse from participating in its consideration or seek further guidance from the Ethics Commission. I'm happy to answer your question.
Before we move to that, I want to note that on page 4, I didn't see this before, but we were talking here, but on page 4, the third line down, we have it as 90 FFL holders. I believe the number should be 99.
Thank you.
Also on the first line of that paragraph, council notes for us. Just check this opinion before you publish it, make sure you have the right numbers in the right place.
I will absolutely do so. Thank you.
Now, to the members of the commission, does anybody have any questions or comments for Mr. Beaches on this one? Commissioner Rabideau.
I just have a generic question, I guess. Has the commission ever set a minimum threshold for a class size?
They have not, actually. They have not.
Just curious, 99 is not
You know,
a large number.
the Ethics Commission has generally found large classes to be more favorable
Right.
to the application, but it has never imposed a minimum class number.
Thank you.
And arguably the class is only 8.
Right.
It gets narrower and narrower, the fewer, the more you exclude. But I think we've had smaller classes, even in my time, so.
So I guess it was not necessarily a question, but to try to clarify whether we have a rule. So if you were to pull the thread in the legislation, there could likely be a financial impact to those owners, the FFL owners, of a very significant level. If there is a passing of this, legislation as it is. Again, to come back to this threshold question, is there some type of application to the value? I guess it's not the fiscal value, but the value of the class size and the impact that it could cause. I know I'm not explaining that well, but I would argue that.
I think I
I think
understand.
you
that.
have
It's just,
Are you asking whether or not if one of the options is to take your weapon and get it to an FFL?
it's more in line with, again, as a third meeting and as a layperson and learning more about the class exception rule, many of the advisory opinions that I've tried to sort of do my homework on. It's a much larger group, as Scott mentioned, Commissioner Roundy mentioned, and the likelihood of impact is generally smaller. This is a much smaller group, but could have an exceptionally dramatic impact on their entire industry. And the value of it, licensing this one legislator, and in his role as this is the Senate majority leader. So that was my.
That's one of the factors to be considered, the foreseeable impact on the members of the class.
As well as the size of the class, the description of the class.
And so then there's. Again, I don't want to delay us, but then there's no consideration or little consideration to that particular role that, in this case, he has in government, which is like more than just a senator, right? We're talking about.
He only has one vote.
Thank
Okay.
To that point, and I may have missed it, where in the analysis of the class exception is the discussion of the nature and degree of foreseeable class?
The nature and
It's
degree
on
of.
page 3.
Page three,
Page
I
three,
see it listed. I see where we talk about how it applies here. In terms of when you discuss the reasons why you think he needs the class exception. I know we talked about the important factors to consider of description. We have the description, we have the size. We know the functional official action, but what is the impact upon the class members here? Where's that discussion? And I think to the point is that you probably would consider that if it's gonna have a really detrimental impact, that weighs against the paper class exception, right?
Not necessarily, we're looking for the same impact.
The same
And they each have the 5 same options under the way it stands now.
Okay, so it's not, you're not weighing the nature and degree of foreseeable impact upon the class. You're looking at, is it the same nature and degree? You're not weighing that as a factor. It's more, is it equal among the class members?
Yes, whether they'll all be impacted the same way.
Okay.
Questions?
Yes, based upon that, the factors or the criteria. You keep referring, correctly, it's for. I think one of those factors individually stand on their own merits. In other words, you could have one that's a leading factor. But others that do, and that one, that nothing defeat, deny the class exception.
No, I'm not sure I'm understanding you.
5 or 4 criteria that establish what the class exception is.
The 4 important factors, the description, the class.
Now, are those collective or those considered to be individual to the point where if one passes the test, the others don't, but
No, it is a totality of the circumstances, but those are 4 of the important factors that are considered.
I understand. But if 2 of those aren't met and 2 are met, does that change your opinion?
Well, one of them, number 3, is the function or official action being contemplated. So that's not really something to be met. That is here, the consideration and voting on the legislation.
What if any one of them are conflict? I mean, I'm not, any experience in that? Anybody here? Find it. I think the point that the Commissioner Rapidu asked earlier, of the operation of the class exception, whether or not whether or not the expansion, or whether or not the impact of the vote petition the individual. I'm curious about. I just don't know the answer. So case by case basis.
I was just opening my mouth to say that. It is a case by case analysis. It's not a perfect science.
No, it's
The big numbers, we love the big numbers. 13,000 teachers, easy peasy. This one, 90, and I do regret saying FFL instead of not license holders, right? 99 license holders, right? He's one of them, they'll all be impacted. He's one of 80 that deal in non-destructive devices. 80 is a significant and definable description of the full class of 99. That's how we went.
I don't see a conflict of percentage over here. I think the point that based upon the factors of the class exception. And as Commissioner, as Chair. It's not the president itself who oversees that thing, it would be the person in a different vein. So I don't see.
Commissioner Senator,
A basic principle of statutory interpretation, but in this case, regulation is, the ordinary meaning of the words. Ordinary meaning of a class is a group. And I think, with all due respect, we got to administer the existing rules and regulations. The existing rules and regulations say a class equal a group. And I don't think we should get into a finite discussion with the facts that are presented as to whether 99 is not enough. I think 99 is enough, in my view. So I would make, if discussion is over, I'd make a motion to accept.
Is there a second? I'm gonna rephrase the motion with your permission to be a motion to approve and issue the advisory opinion as presented by the staff, acceptable to you. Second of that motion, Commissioner Ritchie. Roll call vote. Commissioner Susie. Commissioner Strauss. Commissioner Browner.
Aye.
Commissioner Centerini.
Aye.
Commissioner Callahan.
Nay.
Commissioner Peterson.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie. Chair votes aye. I do understand the discussion we've had here. I think that's an appropriate issue in other contexts. Is it a large enough? And here, by the motion and the approval, we're accepting 90, 80, accept. I agree. I think that we could have that discussion in individual cases. Next one is Samantha Doyle, a community program liaison worker at the Rhode Island Department of Behavioral Health Care, Developmental Disabilities, Hospitals Office of Quality.
This is tab C in the binders. Ms. Doe is not present today. I have a confirmation that she has received the email with a PDF copy of her advisory opinion. She responded to the email stating that she would review the document that same day and she'll get back to us if she has any questions. I tried reaching her following 2 days, leaving voicemails. I haven't heard back from her, so I don't know if she has. I assume she doesn't have questions, but I will leave it up to you whether or not to proceed with the presentation.
Do any commissioners have any concern with proceeding under those circumstances? Because I don't, but if you do, I want to hear it. So, all right, well, we'll hear you.
Ms. Doe is employed as a community program liaison worker by the Rhode Island Department of Behavioral Health Care, Developmental Disabilities, so BHGDH, and she is employed at its Office of Quality Assurance. She requests an advisory opinion regarding whether she may accept secondary employment with Family Service of Rhode Island. Ms. Doe began her state employment in January of this year, and her work hours are 8:30 a.m. to 4 p.m. Monday through Friday. Her duties include answering the department's telephone hotline and taking reports of abuse, neglect, mistreatment, and/or exploitation of persons ages 18 or older who have behavioral or developmental disabilities. She explains that such calls are normally received by workers at the Rhode Island Hospital, group homes, fire department, police departments, from family members of the impacted individuals or the individuals themselves. She assesses the urgencies of the calls. If there is imminent harm presented, she will refer those cases to investigators immediately. If not, all the reports are logged into an electronic system, and then all those calls are reviewed by a team of employees of BHGDH. She is present during those, the review of the calls. However, she represents that she does not participate really in discussions. She takes notes, updates the cases, and or investigates any or obtains any additional information that might be needed on those cases. That She represents that if somebody needs additional services, the case is reference or referred to BHDDH service coordinator, who in turn will refer that individual to appropriate state or private agency for receipt of those services. She has been offered a per diem position with Family Service of Rhode Island as a to-go, I apologize, as a go team on-call and weekend liaison. Family Service of Rhode Island is a nonprofit organization that is focused on improving the health and well-being of children and families across the state. Her duties pursuant to the job description of the positions are listed on page 2 of the draft. If permitted to accept the position, she will be working on cases involving adolescents younger than 18 years of age, and will be advising Family Service of Rhode Island employees or members of a particular police department as to the appropriate state or private agencies to be contacted and how best to access the resources needed for that adolescent. Her duties will be to each month be on call for 1 week and ride along for 1 weekend with a police officer from a police department to which she will be assigned. Her schedule during the on-call week would be as follows. Friday, starting at 5 p.m. Until Monday at 8 a.m. Then it picks up again Monday at 5 p.m. to Tuesday 8 a.m. The same with Tuesday 5 p.m., Wednesday 8 a.m., Wednesday 5 p.m., Thursday 8 a.m. And then the last shift is Thursday 5 p.m. to Friday at 8 a.m. She notes that during that time, she'll be required to be available by telephone to advise employees of Family Service of Rhode Island or police officers. And her hours during the police ride-along weekend will be Saturday and Sunday from 11 to 7 p.m. She'll be riding with a police officer and responding to emergencies. She represents that if upon arrival to a scene, there is a person who is under BHDDH jurisdiction, she will recuse and somebody else will handle it at that time. She also represents the cases involving adolescents are referred to DCYF rather than the BHDDH. She also represents that she might have to write a report that may be submitted to DCYF. And there are circumstances where individuals will phase out of DCYF and be transferred to BHDDH jurisdiction. However, employees of BHDDH do not have access of the file from DCYF. She represents that she will recuse from her BHDDH duties in matters in which she has worked as a Family Service of Rhode Island employee that involved an adolescent who is now under BHDDH care. She also recused from taking and recording the results of calls made by Family Service of Rhode Island to BHDDH, and she will refer those calls to one of the other persons within the department. The Ethics Commission has consistently opined that public officials and employees are not inherently prohibited by the Code of Ethics from holding employment that is secondary to their primary public employment or positions, subject, however, to certain restrictions and provided that their private employment would neither impair the independence of judgment, involve the use or resources of their public office, nor create an interest in substantial conflict with their public duties. I have listed several past advisory opinions on pages 4 and 5 of the draft. Here, based upon the facts presented by the petitioner, there is no evidence to suggest that her per diem position with Family Service of Rhode Island will either impair her independence of judgment or create an interest that is in substantial conflict with her duties at BHDDH. Accordingly, The petitioner is not prohibited by the Code of Ethics from working in her private capacity as a go-team on-call and weekend liaison in the manner that was described by the petitioner, provided that all the work is performed on her own time without the use of public resources. She also shall not use her public position to promote or advertise her private employment, nor shall she list her public employment as part of the advertisement of her private work. Additionally, the petitioner shall recuse from any matter that comes before her in her public capacity that involves Family Service of Rhode Island, or for which an authorized representative of Family Service of Rhode Island appears on behalf of that company, and to refer that matter to her superiors. Ask any questions you may have at this time.
But I have a question. If the call is not from FSRI, how is she gonna check that it's not someone subject to FSRI when she's at work? How is she gonna check that system?
BHDDH only has jurisdiction over individuals 18 and older. So the calls that would come to BHDDH will be for adults.
But she said that there's been calls. Then why is she recusing from, isn't that sort of confused? Anyone else see the point I'm making? That she said she's gonna recuse herself if a call comes in and one of her colleagues is gonna handle it.
That the call that it's made by Family Service of Rhode Island,
Right.
because that
Or
would be her
other-
employer. Or if a case gets phased out from the CYF and gets forwarded to the HGGH and involves an adolescent that she has participated in.
Sure, how's she gonna know that it's one of the adolescents she formerly participated with? She's at work. Can she access the systems? Like, how's she gonna be able to tell that?
My information is that she does not have access to both systems. I would assume she would know, the adolescents that she's worked with as in her private capacity.
Patients, comments?
As I understand, the Family Service is a nonprofit organization.
Correct.
They have substantial contracts with the state of Rhode Island under DCYF. Does that play any role?
She's not employed by DCYF.
Okay.
She said that she doesn't, she's employed by BHDDH.
Guess I'm gonna ask the members of the commission if we're comfortable with the information that we have, particularly Commissioner Peterson.
If she can do it, that's great. It seems like a lot to me, but if she's confident she can handle it, and, I applaud her.
Would you be wanting to ask her that if she were here?
If she were here, I would ask her that. Absolutely. I'd ask her how she's gonna handle that, because I don't wanna make an assumption about how she's handling it, or maybe she hasn't thought of it. I'm not sure.
I can appreciate her not being here
Absolutely,
because she's probably at work.
absolutely.
And she got a favorable opinion that she called its Papa. So I guess my preliminary question is there any sentiment to push this over to the next meeting and ask her to be here? I think Commissioner Peterson, that's primarily a question for you.
No, I'm fine with this.
Everybody else comfortable with it? Is there a motion to approve and issue the advisory opinion as presented by the staff?
No.
Moved by Commissioner Susie, seconded by Commissioner Browner. Roll call vote. Commissioner Susie.
Aye.
Commissioner Strauss.
Aye.
Commissioner Browner.
Aye.
Commissioner Centarini.
Aye.
Commissioner Callahan.
Aye.
Commissioner Peterson.
Aye.
Commissioner Rabideau. Commissioner Ridley. Chair votes aye. The last advisory opinion today is Kurt Wilcox, a member of the West Greenwich Planning Board. Also doesn't happen. And Ricky.
We'll still do that, yes.
Although you might want to just hold for a moment because it's actually go forward.
So Mr. Wilcox is not here today. I received upon sending the advisory opinion to the petitioner, I received an email from West Greenwich, Assistant Town Solicitor, informing me that Mr. Wilcox will be resigning from the planning board and does not wish to go forward with, the advisory opinion, asking if we can take it off the agenda. The agenda was already published, advisory opinions, packets were sent out to the commissioners. I'll leave it up to the commissioners whether or not.
Did he communicate to you in writing his desire to withdraw?
I have an email from, the assistant town solicitor, not from Mr. Wilcox.
What does the solicitor represent, Ms. Walcott?
She does not.
I mean, if we had an email from Mr. Wilcox, it might be one thing.
Let me suggest that we leave this on the agenda as it is, postpone it till the next meeting. If in the meantime, the Wilcox formally withdraws with the writing from Mr. Wilcox, it doesn't go on our agenda the next time.
I can agree with that.
So is there a motion to continue this matter to the next meeting?
So moved.
Motion by Commissioner Rabideau, second. Second by Commissioner Susie. I'm gonna take a voice vote on this one. Is there any opposed? You're here.
I'm completely.
Yeah. Right, you have to fill the
I'm
form.
learning. Yeah, we have.
It's okay.
You want to.
Choosing from that. So maybe I better take a roll call vote. Commissioner Susie.
Aye.
Commissioner Strauss. Commissioner Browner.
Aye.
Commissioner Centerini.
Aye.
Commissioner Callahan is recused. Commissioner Peterson. Commissioner Rabideau.
Aye.
Commissioner Ritchie. The chair votes aye. Is there any question about what we're asking for? Or the procedure to follow? Okay,
Thank you.
thank you. Gets us to a motion to go into executive session to wit. Motion to approve minutes of the executive session held on April 29th, 2025 pursuant to RI General Law, section 42-46-5, A 2 and 4. In Ray Jonathan Pasqua, claim number 2025-2 pursuant to RI General Law, section 42-46-5, A 2 and 4. A motion to return to open session. Is there a motion? So moved. Motion by Commissioner Ritchie. Is there a second? Seconded by Commissioner Callahan. Roll call vote. Commissioner Susie.
Aye.
Commissioner Strauss. Aye. Commissioner Browner. Commissioner Centerini.
Aye.
Mr. Callahan. Aye. Commissioner Peterson.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
And the chair votes. We'll go into executive session.